In this video, we will discuss a Multilateral CSA Staff Notice dated March 8, 2023, that provides guidance for preparing and filing an offering memorandum under the Offering Memorandum Prospectus Exemption. This video is for educational and training purposes only, and for issuers, dealers and professionals who are looking for guidance on preparing an offering memorandum under the Offering Memorandum Exemption. We will also highlight common deficiencies found in an offering memorandum and the potential consequences of non-compliance with the Offering Memorandum Prospectus Exemption requirements. Number 1. Failing to file an offering memorandum on time. Issuers must file a copy of their offering memorandum with the securities regulatory authorities no later than 10 days after the first distribution under that offering memorandum. CSA staff observed late filings and non-filings, which could lead to regulatory scrutiny and potential penalties. Issuers must ensure they have processes in place to comply with filing deadlines. Number 2. Failing to amend the offering memorandum when distributions are ongoing. Issuers must ensure their offering memorandum is updated to reflect material changes and to include recent financial statements as required. Failure to do so can result in non-compliance with the Offering Memorandum Exemption disclosure requirements and potential regulatory action. Issuers should establish procedures to monitor ongoing distributions and update their offering memorandum accordingly. Number 3. Failing to include sufficient information for informed investment decisions. Issuers must provide enough information in their offering memorandum to allow prospective purchasers to make informed investment decisions. This may include disclosure about subsidiaries, as well as other entities involved in the business. Incomplete or insufficient disclosure may result in a misrepresentation and regulatory consequences. Issuers should carefully review their offering memorandum to ensure comprehensive information is provided. Number 4. Inadequately disclosing the issuer's business. Issuers must provide which is not sufficient for informed decision-making. Issuers should describe their business structure, competition, resources, and other factors that may impact the business. Providing insufficient information can lead to non-compliance and potential regulatory consequences. Number 5. Failing to provide balanced disclosure. Issuers should ensure that the disclosure in their offering memorandum is balanced and realistic relative to their current stage of development. Presenting an unrealistic or misleading picture of the issuer can lead to non-compliance and potential regulatory action. Issuers should be mindful of their disclosures and ensure they provide a fair representation of the business and its prospects. Number 6. Inadequately disclosing available funds and use of available funds. Issuers must ensure that the disclosure regarding available funds and their usage complies with the form requirements and does not misrepresent the issuer's financial situation. Common issues include inaccurate information on funding sources, offering costs, working capital deficiency, interest payments or cash distributions, generic descriptions, and payments to related parties. Ensuring accurate and detailed disclosure of available funds and their usage is crucial for compliance and for providing prospective purchasers with a clear understanding of the issuer's financial position. Number 7. Inappropriately reallocating available funds. Item 1.2 of Form F2 under the Offering Memorandum Exemption requires issuers to disclose the intended use of available funds. Issuers must not use funds for purposes significantly different from the stated use of funds, even if disclosure mentions that funds may be reallocated. Issuers should ensure that purchasers are provided accurate and complete information regarding the use of available funds, and any reallocation should be for sound business reasons related to the issuer's stated business. Number 8. Omitting key terms of material agreements. Item 2.7 of Form F2 requires issuers to disclose key terms of all material agreements they are party to, involving related parties. Merely attaching the agreement or stating that it is available upon request is not sufficient. A summary of key terms must be included. Issuers should ensure all material agreements are accurately and completely disclosed. Number 9. Omitting compensation disclosure. Issuers must clearly and completely disclose compensation paid to directors, officers, promoters, and related parties. Compensation should be disclosed, whether or not it was immediately received by the individual, and should include amounts paid to professional corporations or holding companies. Issuers must disclose the total amount of compensation in the table required under Item 3.1 of F2. Number 10. Inadequately disclosing management experience. Issuers must provide accurate, relevant, and clear descriptions of directors' and officers' previous experience and occupations, as required by Item 3.2 of Form F2. Generic or insufficient disclosure can be misleading and inadequate for purchasers to evaluate management's background and ability to operate the issuer's business. Issuers should ensure detailed and accurate descriptions of management experience are provided. Number 11. Disseminating material forward-looking information not included in the offering memorandum. Issuers must not disseminate material forward-looking information during the course of a distribution of securities, unless it is set out in the offering memorandum, as required by Item 8 or 12 of the instructions. Issuers should ensure that any material forward-looking information included in an offering memorandum complies with Sections 4A2 and 4A3 of the National Instrument involving continuous disclosure obligations. Number 12. Omitting required interim financial reports. Issuers must include financial statements for any interim period completed more than 60 days before the date of the offering memorandum, as required by Item B.5 of the instructions. Issuers should ensure they include all required interim financial reports in their offering memorandum. Number 13. GAAP, applicable to publicly accountable enterprises, as required under the National Instrument. Issuers must ensure that each set of interim financial reports or annual financial statements included in the offering memorandum is complete and contains all key elements. Number 14. Failing to obtain required audits, issuers must include audited financial statements as required by Item B.9 of the instructions. Issuers should ensure they obtain and include the necessary audits in their offering memorandum. Number 15. Omitting required audit reports or including non-compliant audit reports. Issuers must include audit reports for comparative financial statements when required by Item B.9 of the instructions. Audit reports should express an unmodified opinion and be in the form specified by Canadian GAS. Issuers should ensure that the audit report included in the offering memorandum complies with the specified form. Number 16. Inappropriately using a notice to reader. Issuers must not attach a notice to reader to their interim financial reports that caution readers about the appropriateness of the financial statements for their purposes. Issuers are responsible for ensuring that the financial statements included in the offering memorandum are appropriate and comply with Canadian GAAP. Number 17. Failing to prepare financial statements in accordance with appropriate accounting principles. Financial statements in an offering memorandum are generally required to be prepared in accordance with Canadian GAAP, applicable to publicly accountable enterprises, as stated in Item B.1 of the instructions. Issuers should ensure their financial statements are prepared using the appropriate accounting principles and avoid using Canadian GAAP, applicable to private enterprises, except for certain acquisition statements. Number 18. Improperly certifying the offering memorandum. Issuers must ensure that the offering memorandum is properly certified, which includes having all required signatories sign and date the certificate memorandum. Issuers should not backdate the certificate, and signatories should have a complete version of the offering memorandum, including required financial statements, before reviewing and signing the offering memorandum. The certificate should be placed after all other items in the offering memorandum, as specified in Item A2 of the instructions. Number 19. Consequences of failing to comply with the requirements. A breach of the offering memorandum exemption disclosure requirement may result in a Canadian securities regulator taking one or more of the following actions, depending on the nature and extent of the securities law breach. A. Requiring the issuer to file an amended offering memorandum. B. Requiring the issuer to prepare and deliver an amended offering memorandum to existing purchasers. C. Requiring the issuer to grant rescission rights to certain investors. D. Imposing a cease trade order. And E. Taking enforcement action. Issuers should ensure they comply with all requirements to avoid potential regulatory actions and consequences. This video is intended solely for educational and training purposes and should not be considered as legal advice. If legal advice is required, please contact a lawyer. Thank you for watching this video. We hope you have a better understanding of common deficiencies with offering memoranda, prepared in reliance on the Offering Memorandum Prospectus Exemption under Canadian securities law.